Good evening. Apologies that we're running a few minutes late. I'm Ben Hopper, Deputy Director of the Intellectual Property Research Institute of Australia, and it's my honour to welcome you to our special event this evening here at Melbourne Law School. Professor Mark Lemley of Stanford Law School's talk on copyright law and generative AI. At the outset, I'd like to acknowledge the traditional owners of the unceded land on which we meet, the Wurundjeri Woiwurrung people, and the traditional owners of country across this land, from here in Naarm on the Bay, all the way to Cape Bougainville in Wunumble-Gumberra country in the Kimberley, Western Australia, home of sacred Wandjina rock art. The traditional owners of this land are keepers of law and makers of rich, profound art and culture. Well, Professor Lemley could not have better timed his talk. Just 2 weeks ago, the Prime Minister, Anthony Albanese, made a major policy announcement on artificial intelligence, including a new Office of AI. As an aside, one wonders sardonically if it will be run by our first AI bot in chief. The Prime Minister also announced the development of Australian standards for AI, and importantly for us, confirmed, quote, "No company should use Australian books, music, art or news to build or train AI without the artist's control. Anything less is theft." And the talk comes at a time when a core question of this whole copyright law and AI debate has arisen due to the important work of computer scientists and legal scholars, including Professor Lemley. The question of memorisation. Do generative AI models themselves contain copies of works? This event has generated a great turnout, close to a full house in the room, and some at last count 120 or 130 joining us online. I welcome each of you and thank you for joining us. This turnout speaks volumes as to the importance of tonight's topic, the deservedly high esteem in which tonight's speaker is held here in Australia, and most of all, the human intelligence of each of you in deciding to join us. I'd like to thank all of those who have assisted in making tonight's event possible, including my colleague, Professor Robert Burrell, who first proposed this talk, Professor Andrew Christie, and Angela Henley-Boyes, and others. There will be an opportunity to ask questions of Professor Lemley. My colleague, Professor Burrell, will chair tonight's event, and I will provide some assistance with fielding the online questions. So please think of questions you have for our Q&A, where we will take questions both from our online audience and here from our in-person audience. So now, without any further ado from me, I will hand over to Professor Burrell, who will formally introduce Professor Mark Lemley.
Thank you, Ben. So for those of you who don't know me, my name's Robert Burrell. I split my time between here and the University of Oxford. And I think for the very first time in my life, I've come to Australia to escape the heat, which is a new experience, although one that we may have to get more used to. I'm really delighted to be able to introduce Professor Mark Lemley. Professor Lemley is the William H. Newcomb Professor of Law at Stanford University, and he holds the honour of being the most cited intellectual property scholar ever. His influence has been profound. I think he's been cited no less than 19 times by the US Supreme Court. And alongside an incredibly productive academic career that spans all of the major branches of intellectual property, he also manages to keep up a fairly busy private practice as well. So he really is able to comment on intellectual property from a range of different perspectives. And I don't want to take up too much time, but I will say that we're beginning to see around the world a really significant group of cases come through dealing with the copyright issues in AI. And within a week, we saw the High Court of England and Wales handing down its decision in the Getty Images and Stability AI case, concluding that there is no storage of copyright works in the Stability AI system. Contrast that with what happened exactly a week later in the Gemma and OpenAI case in Munich. And so I think it's really an important topic, and we're really lucky to have Professor Lemley with us. Thank you very much.
Thank you, Robert. Thank you all. Happy to be here. So we're going to talk about a bunch of different copyright issues that relate to generative AI. And I think it is important, not just for copyright, but for any time you interact with AI, to bear in mind that we call it generative AI because it makes things up. That is literally what it does. So I asked Midjourney to give me an image of penguins having a cocktail party at the beach. This is what it gave me. I didn't imagine the penguins would be in the cocktails, right? It came up with that on its own. But if you ask a different model, this is Dali from ChatGPT, you can get a very different vision of what penguins having a cocktail party at a beach is like. And what's notable about all of these is these are not pictures that it found on the internet and gave us, right? These are things that it has created out of whole cloth, something that did not exist before. How it does that, though, is going to turn out to create a lot of controversy. So there are, at this count, something over 160 pending lawsuits and a few resolved lawsuits involving copyright and AI. Most of them focused on training, and that's where we're going to start. You can see it's around the world. In the United States, always the most litigious. We've got over 100 lawsuits pending right now throughout the country. And so the cases and the issues break into three basic categories. The first, which is where most of the lawsuits have been filed, is the training of AI copyright infringement. But I think increasingly we're seeing lawsuits that ask the question, not just the training, but is the output of AI copyright infringement? And in between, and I want to focus a little bit on that because we have done some research in this area, there's the question of whether the model itself is a copy of some or all of the works that are created. And then I want to turn finally to the question of who owns work that's created by AI. And I think in each of these areas, we're seeing significant and perhaps fundamental changes that are going to affect copyright law and the livelihoods of the people who use it. All right, so why is training an issue? Training is an issue because the way AI learns is it learns by evaluating gigantic sets of data, right? Creating a series of parameter relationships that connect, that tell you what the connections are between those data, and that's how it can generate something new. We live in a world in which if the thing you are copying is at all expressive, it is almost certainly protected by copyright law. Copyright is incredibly easy to get. It covers a variety of things. Everyone in this room has created multiple copyrighted works today, and it lasts for a really long time. And that means that if you gather things from almost anywhere, whether it's books or websites or Reddit posts or images or movies, a vast majority of it is going to be copyrighted. Those copies, though, don't appear in the output in most cases. We're going to spend some time talking about the circumstances in which they do, but as a general matter, AI trains on a gigantic corpus of copyrighted works that the AI companies have acquired. It produces a model, and the model in turn produces things like penguins having a cocktail party at the beach that don't actually appear in the training data at all. Right? In part for that reason, the U.S. courts, which were the first ones to resolve this issue, have so far said, we've got two major decisions, that this training is permissible. Everybody agrees it is prima facie an act of copyright infringement. You are generating a database of a bunch of copies of copyrighted works. But in the United States, where we have a fair use doctrine, the court says, we don't think that database is itself something we should prohibit because the use you're making of those works is transformative. You are not doing it in order to copy and produce output of the infringing works. You're doing it to make a new thing. The copy is only temporary in training the model, the courts say, right? We're building a database behind the scenes, but once we train the model is the thing we use, not the database itself. And the court says there's no market harm, as we mean that term in copyright law. That is, you are not substituting for a sale of the copyrighted work an infringing work, nor do you have, at least based on the record in front of these courts at the time, an established market for licensing the copyrighted works. Now, both of these courts had some significant caveats to them. One of them said, all right, training AI is fair use, but we care how you got the stuff in the first place. And so in the Bartz versus Anthropic case, the court said, perfectly legal to train on a work, but if you got that work from a pirated website in the first place, the act of acquiring it can be illegal, even if the only use you make of it is one that we think is permissible. That led to the possibility of a bunch of damages lawsuits and an ultimate $1.5 billion settlement that was just approved last week. The other court, which also said it's fair use, said, I find that it's fair use, but I really wish you'd made an argument different than the one you made, because I think that argument would have worked against fair use. This is a theory of market dilution, a theory that says, we ought to consider not just market harm from you substituting your infringing work for the copyrighted work. We ought to consider a broader conception of market harm that says, hey, authors are facing competition from new and non-infringing books made by AI. Artists are facing competition from new and non-infringing images of penguins, and that means that your use is unfair. I want to be clear, that is not actually the law in the United States. The judge wants it to be the law, perhaps, but there's a reason the lawyers didn't argue it, which is the courts say that's not the rule. Outside the United States, though, you mostly don't have a fair use doctrine, right? So there are some countries, South Korea's got a fair use doctrine. Some countries have specific text and data mining exemptions that they create, mostly created before generative AI existed, to think about how we might collect and analyze data for research and other purposes. Some of those are quite broad. The Japanese and the Singaporean laws are quite broad. Some of them are narrower. The EU has a relatively broad rule for research, but a much narrower one if you engage in commercial use. The UK rule is specific to nonprofit research. And then there are some sort of countries, including this one, with fair dealing exemptions, right, which tend to be much narrower and more specified than the fair use exemption in the United States. So the fact that this is legal in the United States doesn't necessarily mean it's legal in other countries in the world. As mentioned in the introduction, Australia doesn't have a specific statutory provision on this yet, but we have an announcement made just a week ago that suggests that Australia is going to be very much on the opposite end from the United States, much more aggressive in enforcing copyright law, and we'll see where that goes. We also don't have a final rule yet in China, although the Chinese rule looks like it's going to be more favorable to the AI companies than the European rule at this point. We do have a number of cases outside the United States, as Robert mentioned, including one decided last week by the Delhi High Court, which took a very U.S.-centric approach, applying something that looked a lot like the U.S. fair use doctrine to conclude that OpenAI's training was legal. The Getty versus Stability AI Court, which said, I think, two things that are going to be of importance to us in a minute. One is that the model itself doesn't include the works that you've trained on. That's a factual claim. And the second is training itself ought to be judged by the law where it happens, in this case, the United States, and the UK court, therefore, didn't have jurisdiction over the question of whether training should be lawful or not. By contrast, the Gemma case in Germany, much more aggressive view of jurisdiction. We think we are entitled to rule on the legality of the training, even if that training doesn't happen in Germany. But one of the things that's notable about the Gemma case is that in this case, it's not just the case that we know that you trained on copyrighted works. We also know that those copyrighted works ended up in the output. So in the Gemma case, the model would generate song lyrics if you asked it, please give me the song lyrics for Olivia Rodrigo's Good For You. It'll give you the song lyrics. That suggested to the court a potential copyright problem beyond training, but it also suggested to the court that by definition, there must be those song lyrics stored in the model itself, or we couldn't have gotten them out. So where does this leave us? I think this leaves us in a world in which right now, in most countries, in most circumstances, if AI trains on material it acquires lawfully, we're going to say that's permissible. But if it turns out that the information ends up in the model itself, if the model memorizes the copyrighted work, if it turns out to be output, much more significant risk to the copyright owners. There are a bunch of kind of factual and policy questions that are raised here as you design a system. Whether we should allow opt-out, and if we're going to allow opt-out, how that works. I think a number of courts, right? The Gemma court talks about the possibility of opt-out. The Chinese proposed model talks about the possibility of opt-out. But opt-out has to mean something, those courts say, that's technologically readable, right? You have to have some sort of a standard that an AI can look at and say, okay, I can scrape this, I can't scrape this. You can't just say somewhere on my website, I don't want to be trained by AI, and hope that the AI will read it and somehow know that that's the case. And then I think our questions of market harm are actually going to be really contested. I mentioned already one question, right, which is what do we do about competition from non-infringing works, right? So traditionally, the law has said that's a good thing, right? We want you, even if you learn from a copyrighted work, if you make a non-infringing work and people buy that one instead because they like it better, that's competition and we view it as a valuable thing. That's coming under pressure as AI is making it much cheaper to generate a bunch of works. A lot of people have started to think about what would a compulsory license look like. Maybe instead of preventing training on AI, we could ensure that copyright owners got paid. I think that's going to work better for some kinds of markets than others. If what I want to do is train an AI to make pop songs, and so I want to train it on all the Hot 100 songs from the last 25 years, that's not that many songs, right? Those songs are quite relevant, and I could probably find those people and pay for a license and pay a significant amount of money. If the question is, does an AI that now trains on something like 20 or 30 billion pieces of information, if they have an obligation to pay everyone who has commented on every Reddit post some amount of money for whatever incremental value we think that Reddit post has given them, the amount of money we're going to be talking about, even with a really rich AI company, is going to be really small, and not, I think, what people have in mind when they envision a compulsory license that gets them paid for the use of their work. So right now, I think the AI companies are muddling their way through, right? They have engaged in training. They're continuing to engage in training. And the AI companies, I think, are here to stay. A lot of what we will end up seeing as we determine the legality of training in real time is not, will these AI companies continue to exist? It's, will the next generation of AI companies be possible, right? Can somebody else come in and do the same thing that ChatGPT or Anthropic did some years ago? All right. In the litigation about whether or not AI training is copyright infringement, lawyers on both sides, and I have been one of those lawyers, have taken some kind of fairly extreme positions about how the model works. Plaintiffs' lawyers say, this is just collage. All it's doing is taking the stuff that you've trained it on and kind of like repasting it together in different forms. That's just not true as a technological matter. It's wrong. The lawyers on the AI company side have said, we're not actually sort of taking books and using that content for its expressive value. What we're doing is training the model to learn about word relationships, right? What's the connection? How likely is this word to follow this other word in this context? And that's how we build new text. That's true, but it also turns out to be incomplete. So it is absolutely right that the models don't and can't incorporate all of the data they trained on. I've got one mathematical example here in the slides. The 136 billion estimated images online. If you wanted to make a copy of all of them at 1 megapixel resolution, that would be 68 petabytes of data. Stability AI's model is 6.9 gigabytes of data, 1/10,000,000th of that size, right? You can get something out of that with compression, but if we've created something that actually compresses all data to 1/10,000,000th of its form, right? AI is probably the least significant thing that it will do, right? We've got an amazing tool. That's just not what's happening, right? But it is the case that models sometimes do memorize part of their content. We don't know very much about how or why or how much. But some of the work that I've been doing with computer scientists at Stanford and Yale is helping to give us some information. And I want to show you a little bit of that data. So how do we know there's memorization? One of my favorite things about AI is that even the computer scientists don't really know or understand why AI does what it does. So this is a paper from 2023 that involved what is called the poem attack. The scientist here said to ChatGPT, please repeat this word forever, poem, poem, poem. And the AI happily, dutifully said, poem, 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 poem. And then at some point it started spitting out people's telephone numbers and email addresses. We don't know why. Right, what the connection was, right, that caused it to be a possible logical sort of next token to generate. But we do know that those were actual telephone numbers and email addresses, which means we know that it memorized that information, right? Somewhere in the model, right, there is this person's phone number, this person's email address. It's sitting there latent in the data. We don't know why it picked that and not somebody else's data or some other piece of information, and we certainly don't know why it gave it to us. But sometimes it happens. Right? All right. So you can make it less likely that that will happen, and the AI companies all try to do that by building guardrails around their models after they have trained them, right? So if you're concerned, as you probably should be, and we'll see in a minute, that the model might spit out Harry Potter, you can put in a safeguard that says don't answer a request to say give me the text of Harry Potter, or don't give more than a certain amount of text of this form, or don't use these words, and so forth. People can try to figure out how to get around those safeguards, right? And they do. So the poem attack is one. There are other ones. Actually, for some reason, poetry seems to figure prominently in this. My favorite example is the adversarial poetry attack, different than the poem attack. If you ask a model to do something it's not supposed to do, and it says, no, my guardrails don't allow me to do that, if you rephrase the question in the form of a poem, almost all of the models will actually bypass their own safeguards and give you the thing that you're not supposed to do, up to and including here's how you design or build the nuclear weapon that we were quite sure in the guardrails that we didn't want you to do. All right. So what does this tell us? This tells us this information is in there sometimes. We did a bunch of investigation to try to figure out what information is in there and when. So we ran 200 different books through a bunch of different models. And what we did is we said, all right, here are 50 words from the book. What are the next 50 words that you would generate? right? And the answer is, for many works, we didn't get much. But for some works, we got quite a lot. So memorization varies across models. So for Toni Morrison's Beloved, Pythia gives us almost nothing. We think that actually wasn't trained on the books directly. The early Llama models give us virtually nothing. Llama 3.1 gives us more. The blue lines here suggest that after some number of tries, we could get a verbatim answer. We don't always get a verbatim answer. It also varies for the same model across books, right? So here's Llama 2. Knowing almost nothing about Madame Butterfly, very little about Beloved, but a fair bit about Harry Potter and the Sorcerer's Stone. Why? We don't know, right? Maybe they overtrained on Harry Potter, either deliberately, right, or there's a whole bunch of copies in the training data set they used, and so we reinforced the kind of language characteristics. Most of the books look like Madame Butterfly. Most books in the training data sets that we tested are not, in fact, generally memorized. But there are a decent number of books that look like Beloved for Llama 3. You can get sort of isolated individual chunks verbatim. It's memorized some information, but it hasn't memorized the whole book. And then there's Harry Potter and a couple others like it. There are a couple books where it looks like they've memorized almost the whole thing. In fact, this is the pre-guardrail model. This is the base model. So this will not work for you if you try it at home. But we took a single prompt, Mr. and Mrs. D, and we asked it to continue the sentence. And it said, Mr. and Mrs. Dursley of number 4 Privet Drive were proud to say that they were perfectly normal. Thank you very much. That is the opening sentence of Harry Potter and the Sorcerer's Stone. You can continue. If you take what it just gave you and you feed it back to them, it'll then give you the next sentence. And in fact, using this process, we deterministically reconstructed the entire book with virtually no differences. So you'll notice the differences here are things like, do we spell mum in the British or the US way? There are differences along the lines of, do we have 3 dots and an ellipses or 4 dots and an ellipses? But otherwise, this is the same book. There are occasional more substantive differences. There's a sentence there on the right that it just missed. But Harry Potter is clearly memorized in the Llama 3 model, right? We can generate, it's not only memorized, it's strongly memorized. The connections are such that we can easily generate Harry Potter out of the model. By contrast, this is our effort to do the same thing with Sandman Slim by Kadri, who's one of the named plaintiffs in the Meta case. The blue text here is actual seed text we prompted from Sandman Slim. The black text is what it generated. None of those words are actually in the book. There's nothing here. Now, what's odd about this is it uses the term Sandman Slim. It makes reference to James Stark, who's a character in Sandman Slim. It clearly recognizes and understands word connections that suggest that this is coming from the book Sandman Slim, but it will not generate, it doesn't appear to have memorized the book itself. So, the other problem associated with this is, with a few cases like Harry Potter, we can do this deterministically. We just say, give us the most likely answer, and it gives us Harry Potter. Most of the time, though, when we're able to get text out of a model, it's because we run it 10 or 100 or 1,000 different times. And that's because models, by their nature, are not deterministic. They are deciding on a word-by-word, token-by-token basis, given the words and the context that have come before, what's the next logical word that should flow from this? And they assign percentages to the possibilities of those things being correct. That means that you won't necessarily get the same result each time, right? So with Harry Potter, the answer is actually pretty kind of heavily weighted towards Mr. and Mrs. Dursley, right? If you say Mr. and Mrs. Durs, you get a 99.22% chance that the model, the llama is going to generate Lee in the end. It could have been Dursky. There was a small chance of that. Then we're probably going to give you a comma. We're a little less likely to give you a comma, but it's still the most likely thing. But there was a 0.5% chance we were just going to go randomly off in a different direction, and the next thing it was going to say was /n. right? And once it said /n, I guarantee you, you were not thereafter going to get Harry Potter. You were going to get something that sort of seemed, might not be English and went off in a different direction. So you won't get the same result every time. We can show kind of probabilistic rates. If you say, all right, how much of the book can we memorize if we run this 1,000 times? Can we generate this answer? And that's the kind of orange bar here, right? So we can extract some amount of all of the works. Not that much. It's like 0.5% of the work. I mean, but it's real. But it won't happen every time. It won't even happen most times. Most of the time you ask this prompt, you'll get something different that it is not the text of the book. For each book, we do this kind of probability analysis. Here's Great Gatsby, which is pretty highly memorized. So for Llama, we can get a 35% chance of getting the text of the work. That's pretty high. But 1 in 1,000 chance, that's not particularly high. And so if you look over here on the left, the color shading tells you how likely we were to get it. If it's super dark, we get it all the time or almost all the time. But if it's a kind of light blue, that might be we took 100 tries to get this text. Now, again, that's not nothing. It's pretty good evidence that it has in the model some information here. But it's not clear that we should say, oh, the model therefore stores a copy in some deterministic sense. We wouldn't say it stores a copy of all of the other possible paths it could have taken down the tree. Mr. and Mrs. Dursley /n, right? That's not stored. We wouldn't say that's in the model. So if we're asking the legal question, is the model itself a copy of the works? Copyright law is just not used to asking questions about probabilistic rather than deterministic outcomes, right? We know we want to know the answer to the question. Look, it's in there or it's not in there. And if the answer is, maybe some of it's in there. If we try hard enough to generate it, it's a problem. So just a brief note here, all of what I've been talking about is verbatim extraction. That turns out to be the easy thing to test. Cooper and I have a kind of new method that allows us to test things that are close but not exactly the same, right? So if you, the way you normally test verbatim, you say, all right, what's the most likely answer? If it's identical, we count it as a copy. If it's even a little different, we don't count it as a copy. So here we changed a period to an ellipsis. There's one difference there. Here we deleted a comma and a space. There's 2 differences there. Those things don't get caught as verbatim copying. We wanted to make sure we could catch this kind of near verbatim copying, especially because, right, in this particular example, if you just said what's the most likely thing, the most likely thing is not quite identical. It's got one difference. It wouldn't have shown up as identical copying. So we've expanded the world in our most recent paper to reach what we call near verbatim extraction, because all of these things are pretty clearly copyright infringement. You don't have to be identical to a work to be infringing, right? All you got to do is be substantially similar. All these things with these minor differences are still pretty substantially similar. So if you do that, you actually then expand the universe of things that are memorized. By how much you expand it depends, again, on the model and on the book, right? And so with Llama 2, here's a bunch of different, on the Great Gatsby, these lines show you kind of how much of what we managed to extract was verbatim extraction. So if 27% was verbatim, we've now just quadrupled the amount of memorization or copying we can show once we add in kind of near verbatim extraction. So what that tells us, I think, is there's more out there. We don't know exactly how much more out there. We're all still trying to figure this out. But what we do know is that it's complicated, right? And that's a real challenge if you're a class action litigator, plaintiff or defendant, right? Because what you're asking the court to do is to say, hey, is training legal or is it not legal, right? Have you made copies of these books? Have you memorized the books or have you not? And the answer is, depends on the model. It depends on the book. Depends on how you test it. We're going to have to figure it out case by case. Memorization is not just a single number, lots of different memorization models. One final note here, this is not just monkeys at a typewriter. Right, so you probably know the classic reference that if you set an infinite number of monkeys on an infinite number of typewriters, they'll write the words of Shakespeare. That's true, but that's not what's happening here. Right? If we did that for the kinds of works we're talking about, the chance of doing it from the model is about 1 in 10 quadrillion. That is just to sort of put it in chance terms. That's like winning the lottery 34 million times in a row. It is possible if you do it long enough, but it is really unlikely. So what we're seeing here is many, many, many orders of magnitude more similarity than we'd expect by pure chance. All right, so what does this mean for the law? We don't know yet. It is worth noting, right, that the Getty and the Gemma courts split on the question of whether the model memorizes the words. They care a lot about that question. The answer, I think, now is it's complicated. It might still be a fair use under U.S. law if the model is in turn generating new content, but maybe not. All right, and that leads us to the output question. Is the model, in fact, generating infringing content? And the answer is usually no. So Anderson versus Stability AI is the first lawsuit filed. This is a Sarah Anderson comic on the left. I asked Stability AI to give me a Sarah Anderson comic. It gave me the thing on the right. I think that's an effort to draw Sarah Anderson herself very poorly in comic style format, but it is very definitely not a copy of anything on the left. This is what normally happens, even if you ask for something that might be infringing. But there are exceptions, right? One exception we just talked about is memorization. If there's a bunch of stuff in the training data, we might memorize it. We might generate something which, even if kind of modified, is clearly a copy of a particular photograph of a particular individual, probably because there aren't that many photos of this person and there are a bunch of copies of this one floating around on the internet. So the model memorizes a bunch of copies that all have the same tag associated with them. Harry Potter is another example of memorization. Sometimes when we get output that comes from these things, it's because of deliberate efforts to prompt infringement. Right? If you ask ChatGPT to give you a story about kids who go to a British wizarding school, it will not give you Harry Potter or anything like Harry Potter. But if you ask it to give you a story about kids who go to a British wizarding school that begins with the first paragraph of Harry Potter, then it will actually start, for a while at least, to generate some of the text before it disagrees. Now, that probably is evidence of copyright infringement by the model. The model is generating infringing output. Might also be, though, that the real person who we ought to hold liable is the person who is deliberately trying to prompt infringement. We see this, interestingly, most commonly with plaintiffs' lawyers who go to great lengths to try to generate output that looks like their original inputs that we know that they know it was trained on, generally without success. So this is from the Getty versus Stability AI case. The lawyers here spent a lot of time writing very detailed prompts. You know, give me a picture of football players taken at eye level with two players, one in a white shirt and one in a red jersey, with arms and legs akimbo fighting over the ball. And they still didn't get something that I think we would say is substantially similar from a copyright perspective to the photo. Sometimes you do get something quite similar. This is OpenAI versus New York Times. But you do it by saying in the prompt, please give me the New York Times story of this title that begins with these 6 paragraphs. And then it's pretty good about spitting out an identical copy. Again, that probably is infringement. Although we ought to ask the question, who's doing the infringing, right? At this point, do we view the person who's kind of like trying to hack the system to get an infringing output, trying to get around the safeguards as the actor? Do we view the AI company as directly liable, or maybe both? Artistic style is another interesting problem. A lot of people ask for images, things in the style of. Copyright law at least says it doesn't protect artistic style. We don't always mean it. But we may want to rethink that in the world in which it's easy to generate artistic style. ChatGPT has a Studio Ghibli filter. You can take any picture and turn it into something that looks like a Studio Ghibli cartoon. Studio Ghibli, which is notoriously anti-technology and hand draws all its stuff, even if we say there's nothing copyrightable about this from Studio Ghibli, right? There's no kind of actual imagery or text that's taken, but maybe we ought to feel a little concerned at the point that you can now turn style copying into kind of big business. And then there are characters or circumstances, right, where you're just going to get the output because the model recognizes the character as a category. You can get a really good Darth Vader out of Midjourney because Midjourney's trained on a whole bunch of pictures of Darth Vader. It knows what the concept of a Darth Vader is, and boy, they look alike, a lot alike. So it will generate a Darth Vader just like it will generate a penguin. It's just that Darth Vader turns out to be copyrighted. And so this is unquestionably, I think, an act of infringement. So there's some other cases going on. There's a CGEU case pending, but I'm going to skip over that a little bit because I want to say something about the last issue, which is authorship. So who owns the output of AI-generated works? The answer in most countries, UK probably a notable exception here at the moment, is nobody. Because the courts in most jurisdictions say only humans can be authors. Well, or corporations. We treat those as at least as human, at least as personable as humans, at least in the United States. All right, why can only humans be authors? It's this guy's fault. This is Naruto. Naruto is a crested macaque who famously several years ago picked up a photographer's camera and took this selfie. The selfie went viral. And once the selfie went viral, the guy who owned the camera said, hey, it's my camera. I should be the copyright owner. I'm going to go register this and collect all the money from this viral image. People for the ethical treatment of animals sued and said, no, the monkey should be the copyright owner. The monkey is the one who took the picture. This went to the Court of Appeals in the United States, which said monkeys can't own copyrights. They can't be authors. Only humans can be authors. On the strength of that, the courts have said, including the D.C. Circuit in the Thaler versus Perlmutter case, work created by AI is not copyrightable at all. And that's true even where the work, like this, is a painting or something that would clearly satisfy the threshold for originality and creativity for copyright protection. The Copyright Office does say you can get protection for the parts the humans contribute, but only for the parts the humans contribute. So in this case where the AI drew the pictures and the humans wrote the text, they said, fine, you can have a copyright in the text you wrote, but you own nothing around the pictures. Even pictures that, this is Théâtre d'Opéra Spécial, which won an award at the art show until they found out it was AI generated. Here the artist says, I tried 600 different prompts until I got one I liked. Court says, too bad. Right? The thing that was made, the thing that has the creativity, that was human generated. It wasn't human generated, it was AI generated. AI can't be a copyright owner. All right, so most, I think, countries follow this approach. The EU does, Japan does, South Africa does. China is a little bit in flux. There are some Chinese cases that go the other way, but not all of them. The UK happens to have a statute written 40 years ago, and not with AI in mind, that basically said, if there's a computer-generated work, sure, we'll just give it to the person who arranged for the creation of the work. So we may see, we have copyrightability in the UK and a few countries that have sort of copied that legislation directly. But in most countries of the world, if you use AI to generate something, you don't own that thing. So this is going to create a real mess. For various reasons, right? First off, it's going to mean, like, even if a human sort of contributes something, rarely is it going to be the case that what the human is contributing is actually the thing that's got the value, right? So my contribution, penguins having a cocktail party at the beach, that's an idea. I can't protect that. Maybe if I had some detailed suggestions about how the penguins should be done, I could get some thin amount of protection for those things. But the thing that we used to protect copyright with copyright, because the thing that was hard to make, which was the actually turning the idea into expression, the brush strokes, the kind of all the artistic decisions, AI is doing that for us, and we don't own it anymore. Corollary of that is it's actually really hard to tell if your image is similar to mine, but I generated mine significantly using AI. Did you copy from me? Did you use the same AI I did? Did you use a similar prompt? Is it coincidence? Copyright law is really going to struggle with this. And we might ultimately just end up finding that we don't own nearly as much as we thought we did. That is definitely going to be true in the software world, where the vast majority of software right now is being written using AI tools. Those programs are not copyrighted. Interestingly, Claude Code, Anthropic tells us Claude Code is entirely written with Claude Code. So Anthropic may not own its own computer program, Claude Code, because it generated it with AI, no copyright. We're moving to a world that might thrill Richard Stallman, right? We might be moving to the sort of open source paradise that we envisioned 50 or 60 years ago. But I think that world is going to be quite a surprise to a bunch of companies that are in the business of selling software and don't realize they're about to lose the rights that they own. All right, so where does this leave us? I think the training suits are an existential threat to AI. If you say training is illegal, you can't train on anything copyrighted, you can't really build an AI. You could build a kind of hobbled one based around everything people said before 1930, but the text is going to look very different than it did today. I don't think that's ultimately going to be the way we come out. Some countries will reach that result, but not all countries, and so there's going to be AI training in the countries where it's legal. The model itself may be a copy of some works, but it's complicated. There will absolutely be infringement by AI, and the AI companies, I think, will be liable for that, but it's going to be an occasional thing. It's going to be, oh, you generated Darth Vader. It's not going to be a sort of fundamental across-the-board thing. And then I think as the law stands right now, as AI creativity becomes rampant, copyright's role starts to go away because we don't own things anymore. My guess is that's not the way the law stays. There are a lot of businesses with a really significant vested interest in owning creative works, and they're going to say, hey, wait a minute, I want to own my software. Hey, wait a minute, I want to own my movie, my video game, even though I used AI to generate it. So my guess is we'll see a lot of efforts to change the law and to say you can own AI-created things. But it's also, I think, sort of worth reflecting on the question if the point of copyright is to encourage creativity that requires hard work. If we take the hard work out of the equation, if the machine does it for us, whether we need copyright at all. And with that, I'll stop.
That was an incredibly illuminating speech. Thank you so much, Professor Lemley. I've learned a lot. And one thing I'm sure at least the practitioners will take away is that we can use poetry to get around and prove infringement. So would you please join me in thanking Professor Lemley?